Hi there, folks, and welcome to another episode of the Probate Notes podcast. I'm your host, Sam Price, and I have with me today a special guest, a good friend of mine, Kevin Snyder of Snyder Law PC. He's going to be telling us about will contests. Kevin, welcome to the show.
Sam, thank you for having me. It's a pleasure.
It's an absolute pleasure for you to be here. And what I'd like to do is kind of get started. Just let's hear about you. What's your background and what got you into where you are today?
I like to say that I'm a husband, father, and then an attorney, which is all true. Where I'm at as far as the legal practice, right now I have my own practice in my home base is in Irvine, California. We handle estate planning, administration, and litigation all throughout the state of California. So we have offices in San Jose, Pasadena, and up in Walnut Creek. But I live in Orange County, so you'll more likely find me down in Irvine. We have a nice practice. We have about 12 people in our practice, 2 attorneys, and that's what we do every day. We help families protect their dreams, administer their dreams, and then defend them should they need defending in court later.
That's great. That's wonderful. Thank you. We were going to talk about will contests today. Why would someone need a will contest?
The first reason is that they disagree with what's in the will. So they've received, someone's passed away, there's a decedent, and the normal process is that heirs or those named as beneficiaries in the will are notified. And so if you're reading the will and you're saying, wait, I disagree with what's in the will, then that's usually the standpoint that the more common will contest is I disagree with how this was written, what the content is in it, or maybe how it was executed. Those are the general or common reasons why we would contest a will.
And so if we're looking at a will that's been presented for probate, what are the requirements basically of a will?
You can first and foremost, you can create a will yourself in your own handwriting. We call that a holographic will. And California allows for holographic wills. So that means you sit down with a piece of paper and a pen and you, in your own handwriting, write out your will. And you, in that situation, it has to be in your own handwriting, and you sign the will. And usually you'd want to reference your name, and in that will you say, well, people that you'd want to leave things to. But there's no special language in a holographic will. It just has to be in your own handwriting. Now, the challenge, of course, is that now we have to, after you've died, prove that that's your handwriting. In addition to some of the other situations that could be presented, did you have capacity? Were you being influenced? Like, was there a gun to your head when you were writing the will? Assuming that those things weren't present, we just found a piece of paper that you wrote your wishes down for what happens to your estate, and you signed it, and there's a date on it. We have to, and sometimes there's not even a date, right? So the date's not a requirement; it's just in your own handwriting. So that one's, of course, we don't like those because there's a lot of problems potentially with those. The more common one is, well, I've gone to a lawyer, I've used Trust and Will Maker or LegalZoom. I have something typed up. I used a computer. I typed it up. Well, in those situations, then the requirements are that you have to sign it in the presence of 2 witnesses. The 2 witnesses cannot be anybody that is going to receive any be a beneficiary either initially or residually in your will, or have any role in your will, like be your executor. They can't have any tie to say, they can't have any tie to your will at all. They have to be completely independent, and they have to actually witness you sign the document. So you can't just sign it and say, hey, be my witness and sign over here. And you have to have 2 of those people in California. Other states either require an additional notary or allow for notary instead of a will. But in California, we don't have the notarization requirement. The requirement is 2 witnesses.
Now, let's say you've someone else is bringing a will to probate. They're petitioning to admit the will to probate. You think there's something wrong with this will, so you file a will contest, and you filed it on time, and you filed the right paperwork, and you did your little checklist and make sure you've got your paperwork right and tight. Who has to prove what in a will contest? What is the burden of proof?
So it depends on the posture of the case. So first, we'll start with what you stated is that the person, there's a proponent of the will, that person who's petitioned to be the administrator, and they've given the copy of the will to the court. They're the proponents of the will. They have the burden in that scenario to prove the validity of the will, because they're propounding the will. They're giving the will to court, saying, "Hey, this is valid." So the court saying, "Okay, prove it," and then so they're the ones that have to prove it. So if you're challenging at that point and you're saying, "Okay, well, I don't think that that's right," then they have to prove it. If they don't prove up the will, then there's nothing you have to do. It's kind of like a prosecutor and defendant. The prosecution has the burden to prove, the defendant doesn't. The prosecutor makes the accusation, and if they don't prove it up, then the defendant doesn't have to say a darn thing. That's the same here. Now, what is the burden of proof? I just brought up criminal court. That burden of proof is beyond a reasonable doubt. That is the highest burden of proof there is in our great country. That is not the burden of proof when we're here for a will contest. It's by preponderance of the evidence. And how that is different from beyond a reasonable doubt is a preponderance of the evidence. And if we look at it more likely than not, or a percentage, 51%, 49%. Now, we don't actually do the percentages. There's not a scale of justice that we're getting the digital scale out and says that, but that's what we use to describe what preponderance is. It's just a little bit more than not. So it is not the lowest burden, but it is a lower burden than certainly beyond a reasonable doubt. And in between preponderance and beyond a reasonable doubt, there is clear and convincing. So if we're looking at this like a scale of levels of proof, we have probable cause, which is way down here. Then that's probably maybe enough to, hey, we should probably look into this more. We don't just throw it out of court, either criminally or civilly. And then we have preponderance, then we have clear and convincing, and then we have beyond a reasonable doubt. So it's like the second level. So it doesn't take too much to get there. Then what happens? If the propounding party, the petitioner says, all right, the judge says, well, we got there. So I otherwise, unless I hear differently, forever hold your peace. This is valid. Well, if you have objected, now the burden shifts to you, the objector, to now say, well, wait a minute, judge, you didn't hear the whole story. And then you have an opportunity to bring in the rest of the story, i.e. your evidence to show why this will is invalid. So now you have the burden. And because we're fair, we don't give you a higher or lower burden. We give you the same. It's preponderance of the evidence. So if you meet that preponderance of the evidence, and now you win, in the sense that now you have rebutted the presumption, or you rebutted the preponderance finding, you win. So if we looked at it all together and we said, hey, if we all just got in a room together and we're King Solomon back in the day, and we're saying, okay, you speak, and then I will decide. It's the net effect is the same, except procedurally, we're saying, you speak over here, you're the one bringing this will. If you can't convince me beyond by a preponderance of the evidence, I don't even need to talk to this guy over here. So that's not like King Solomon, that's different. That's how our judicial system, these probate rules were set up. Is it fair? Is it not fair? One can argue either way. That is the procedure, and those are the standards.